Good evening. This is John Milburn for Laws 12063, Advanced Statutory Interpretation and Drafting. This is week 4. This week we're going to deal with some information that might help you with your assessment pieces. I do hope that you're well underway, but if not, the information we're going to look at tonight might help to get you started. So if you haven't started, please do so this week. Have an outline of your work and have a clear idea of what you intend to do. The first thing I would like to do is share the screen and give you some information, if you haven't already found it, about the Law Reform Commission of Australia. So we have here a link to the Australian Government, Australian Law Reform Commission, and you'll see that there are a number of tabs that you can follow. Of interest tonight is the links tab to Law Reform, Presentation and Publications. You'll see that there's a list of publications, papers and speeches about law reform, and if you look at that link, and I know that some of you already have, and thank you for providing comments and information in that regard, you'll see that there's a vast array of material in relation to law reform topics generally and specifically. And you can look for ideas on a range of topics through this website. You'll see on the right-hand side the list of all topics. You can follow the links either directly on the left-hand side or through the right-hand side. Now, let's take an example, and this is purely an example. This is not a hint as to what I think you should do. It's almost a random choice, but one that I looked at a little earlier. So if we go to freedom of, you'll see that there is a range of different freedoms available to you. And one that caught my eye for no particular reason was traditional rights and freedoms, encroachments by Commonwealth laws. This is from March 2016. If we follow that link, you'll see that we have further valuable material. An executive summary, and you can download that summary here by following the PDF, or you can go into the full report. You also have information about the terms of reference, etc. So here's the report that was tabled in March 2016. And you'll see on the right-hand side the table of contents. So you have the digital links to information, or you could download the PDF report in full and access information that way. Now, in looking at this information, within this area, you have a range of practical issues and legal issues that could be the subject of your assessment piece. You could choose any one of these, and this is just one random sample from a whole range of other materials. So let's have a look at, for example, fair trial. Expand on that, and you'll see that there's information here about common law rights, amongst other things. And this caught my eye because it provides valuable authoritative information about the subject matter. So if you're looking to develop legislation in response to a perceived need, then this will give you great information and provide you with authoritative information that will help you in the process. I know that some of you have already been accessing those materials, so thanks for doing so. Greg has joined us, and thank you, Greg. I think you were one of those people that I'm talking about. All right, so are any questions then about accessing material that will give you some ideas about the assessment piece or the Australian Law Reform Commission website? Okay, so just when it comes to doing your work for the assessment piece, what you want to do is think about some form of banner statement. It might be a presumption, for example. And then once you've identified your primary thought, just expand on that in terms of providing some additional commentary, perhaps refer to some case law or some academic writings and talk about how the law operates at the moment and how it might be used in the future. So last week we were dealing with common law presumptions. That's why I went to common law rights in the Australian Law Reform Commission material. And remember that if you intend to modify or extinguish a common law presumption in your assessment work, you must do so by clear words. So for your assessments, I'll consider your ability to identify and, if necessary, modify or extinguish existing rights. To identify common law rights, and the common law, remember, will be assumed as if there is a meaning at common law, I will assume that you intend for that meaning to apply unless the context of your material suggests otherwise. Okay, so that's just adapting some of the material that we've got there to your assessment work. Another valuable resource available to you is through the Office of the Parliamentary Counsel. I'm sure that many of you have found this already. I'll just share the screen so you can look at it. And if you're stuck for ideas, which you really shouldn't be, here's another source of material that could be greatly advantageous to you. All right. So what you might be asking yourself is, in relation to this assessment piece, is it real life? And I think the answer is overwhelmingly yes. So you need to be in a position as a lawyer to promote a cause. And I think the commentary in week 1 study guide in this regard is excellent. I'll just read it. This is from the study guide. So you're sitting at work, enjoying a slow afternoon, reflecting on how absurdly lucky you are to have landed a lucrative career at a freelance legislative drafter. You get an email from a client. It's an insurance company. And the email says in part, as you might imagine, the recent floods have cost our company a great deal of money. Our profitability is likely to suffer. We're examining ways in which our financial exposure can be reduced. One important fact has emerged, and that is that we pay substantial claims from motorists whose vehicles are damaged after they drive into floodwaters. And now, so this is a realistic type scenario, isn't it? You could imagine this if you're working in a commercial context, being approached by, say, an insurance company with this sort of thing in mind. They say, we'll soon start lobbying the state government for changes to law to make it an offence for motorists to drive into floodwaters. Please advise the type of statutory instrument that would be required to give effect to this proposal. At this change, we don't require the actual instrument. We just want to know what government would be required to do if they agree with our position. The reason I like that example is that it does establish a realistic situation, and it asks you to be creative. And in order to be creative, you have to understand the platforms, you have to understand how legislative statutory instruments work in with each other, and be in a position to give advice as to the best way to make this law change happen. So, hundreds of years ago, we didn't have these sorts of issues, in the sense that there were disasters, of course, but the law was based around the common law, and statutes was a minor player. Now, overwhelmingly, that's reversed. So you need to understand the statutory process and consider the different ways that this might be implemented. So in terms of looking at that example, but in the context of your assessment work, you need to ask yourself a few questions, I guess cascading questions. If you were to promote this change of the law, you need to ask yourself, firstly, does Parliament have power to make the change? Which may require you to consider the Constitution. Of course, we all know the Commonwealth Constitution, the State Constitution. Have a look at section 51 for the powers when we're dealing with the Constitution of the Commonwealth. What do you then need to do? You need to consider the existing laws, statutory and common law, and then in proposing the new law, Parliament needs to consider one or more of the following. What is the mischief the lawmaker is trying to prevent is number one. What's the risk that the lawmaker is trying to manage is number two. And what is the benefit the lawmaker wishes to maximise? So they're the three key questions that you need to ask yourself, and I think reflect in your assessment work when you're looking at changing laws and drafting legislation, for example, to modify the existing law. Now, of course, in real life, creating a new statute is not the only way to change the legal position. And in fact, in the scenario that we mentioned, it's very unlikely, as is reflected in the notes, that there would be new legislation to deal with that issue. There'd be other ways to deal with it. But when we're talking about creating new laws, whilst we think about a new statute as the primary way to do it, there are other ways to do it. So here are the five that I want to talk about. Number one, create a private law instrument. What's a private law instrument? Well, a contract or a deed. It might be a restrictive covenant, for example, or some form of agreement. So in the scenario that we were talking about with the flooding, why not just simply change the insurance contract, which changes the law privately between the insurance company and the insured? However, the downside is it only binds the parties, and of course it doesn't have retrospective operation. Not that you necessarily expect the law to have retrospective operation anyway. So that's one way that you can change the legal landscape without changing the statute. Another way is to undertake some form of executive action. A government agency, minister or public service may have delegated power to bring about the change. So if there is that delegated power through executive action, then why not implement that? I'm not talking about delegated legislation, that's number three. Number four, create an entirely new Act of Parliament. That is unlikely. And number five, which is possibly more likely, amend existing legislation. So in the scenario that we were talking about with you being consulted by an insurance company, odds are that if you were going to lobby for something, you'd lobby to either amend existing legislation, like the Transport Operation and Road Use Management Act, or create some form of delegated legislation, some regulation or rules. Okay, I know I'm doing a lot of talking. Thank you for staying with me. Are there any questions, comments, or are we all good? It looks like all good is the answer. Okay, thank you. Right, well, let's move on. And this is the last thing that I want to mention about the assessment piece specifically for a little while, because for the next few weeks, we're going to move into an area that's of particular interest to me. We'll come to that soon. But the last thing I want to mention is this. It's to do with the Legislative Standards Act of 1991. Now, please tell me that you've looked at this. Can I have a quick thumbs up or yes? Legislative Standards Act 1991, Queensland. Good. Now, the reason you need to consider this when you're drafting new legislation is that certain things must be considered. So have a look at section 4, subsection 3, which deals with a few things. The first is that obligations are dependent on administrative and subject to appropriate review. Legislation should be consistent with principles of natural justice. Legislation should not reverse the onus of proof in criminal proceedings without adequate justification. And legislation should provide appropriate protection against self-incrimination. Again, that can be changed by legislation, but these are, through the standards, we see, if you like, some of the common law presumptions that we talked about last week reflected in the statutory regimes. All good? Okay, let's move on. This is, I think, an excellent book. I hope that you've all acquired a copy. So this is the complete guide to English usage for Australian students. It is, of course, not a text specifically designed for lawyers, but much of what is contained in it directly relates to lawyers. And those of you that have worked with me through Introduction to Law, Statutory Interpretation, other subjects that I've taught, you understand that part of my philosophy, and I know I've said it before, I'll say it again, I won't harp on it, is keep things very simple, write in the active voice, and do attempt to communicate with the recipient of the communication in mind. And generally speaking, the recipient of the communication is someone who is an ordinary member of the public. So even if you are addressing a court, even if you are writing to a sophisticated audience, I recommend that you still work towards simplicity in language. If you can use a simple word instead of a complex word to the same effect, then do so. If you have a long, convoluted sentence, break it into 2 or 3 sentences, and if it is in the passive voice, change it so that you write in the active voice. All good with that? Okay, so in this fourth topic, which deals with Ramsay's book, so when I talk about Ramsay, that's Margaret Ramsay, that's this book. Chapters 19, 23, 24, 25 is the prescribed reading. So you need to understand the difference, bit of grammar here now. So understand the subject, the object, the predicate of a sentence, identify their roles, distinguish between the phrases, principal clauses, subordinate clauses, distinguish between the tenses of English language, distinguish between active and passive voice, and difference between personal, relative, demonstrative, and interrogative pronouns, and identify their importance and different logical construction of sentences. So have a look at that in your reading, in your study guide. They're the objectives. I think you know which of those I think are the most important. So here's a tip. Many questions in an examination ask you to interpret or analyze or evaluate or explain or make a statement by inference. And you cannot properly answer those questions unless you understand what is meant by the relevant skill. So there is a crossover between terminology. So please look at that. I've previously in other subjects gone through a quick list, but if you look at the list of keywords and their meanings in the preface to Ramsay's publication, this is at Roman numerals 7 and 8, you'll see that there's a list of key terms and the consequent meaning. That's a pretty valuable resource right there in the preface to the material. So for example, interpret, let's see what Ramsay says. Interpret means explain the significance of the information given. You know, I would take that, at least those 2 pages, into pretty much every examination I sit. And the reason is that you want to look at that first word and then work towards providing an answer, a response that deals with the key term. So another one is analyze. Analyze means examine in detail in order to show the meaning. So by understanding the word, following the guidelines, it gives you a great way to map out your assessment piece in an individuated examination. Okay, as I mentioned the prescribed reading of those chapters that I mentioned earlier, there is also some reference reading, and that is on the website. So tonight we're talking a bit about grammar, and it tells us about the rules on how to put words together to convey a meaning. As I mentioned last week, legal writing is not entertainment, therefore use simple words, as few of them as possible, venture further at your peril. I hope you're duly warned. So grammar can give us the same words in a different meaning. and the same meaning using different words. So it's very interesting. But some basics, and you'll read about this in the material, but just by way of a refresher. A phrase does not contain a verb. The applicant contacted the respondent on 6 occasions between December and January. That phrase, on 6 occasions between December and January, does not contain a verb, so it is therefore a phrase. But clauses do contain a verb, and pronouns step in for a noun. Can anyone give me a quick example on the chat facility of a pronoun? This is just testing if you're still awake and you've done some advanced reading. Pronoun? How about I? That steps in for a noun, doesn't it? So pronouns allow for efficiency of language, but in using pronouns, you do risk ambiguity. So often, and this is true, often I will stop clients who are providing me with a statement, or I'll stop participants in a mediation and I'll ask for clarity. Because how often have you been involved in a discussion where someone, particularly if they're excited, they're speaking quickly, they're saying, he did this to that, he did this and then went there, in which case, okay, who's he and where is there? So you can see that what that person has done is used pronouns instead of the noun, and the use of the pronoun in those circumstances has led to ambiguity. I hope that makes sense. One of my little concerns, little pet hates, is capitalisation, over-capitalisation. I think generally students over-capitalise. I was guilty of this for a long time. I've trained myself not to do so. There is a place for it, and if you have a proper noun, then by all means, you can capitalise. But just think about this sentence, and I'm going to ask you a question at the end of it. So listen carefully. In fact, it's 1.5 sentences that I'll now read to you. The High Court of Australia sat yesterday. The main matter before the court was ... Do we capitalise the second court, or is it lowercase? The High Court of Australia sat yesterday. The main matter before the court was ... So the votes are coming in. I've got 2 votes so far. Do we have any others? 3 votes. All right, good. You're giving me the answer I wanted. It's lowercase. Lowercase, that's it. So punctuation is an evolving process. For example, previously, you may have used a contraction. That's not necessarily common. So for example, when you type Mr. MR, the abbreviated form of Mr. MR, back when I started, we had to put a full stop after the MR. Now we don't do that. So there's been a shift, and we use less punctuation, but it's an evolving process. Does anyone know what I mean by, previously I went, the main matter before the court was ... Do we know what that ... is called? And when we use it? So it's called an ellipsis. And when do we use the ... bit? That's very technical language, isn't it? The ... bit. When do we use that? Any thoughts? I told you you'd really enjoy tonight. Tonight's good. We've got 3 weeks of this. All right, we use it when there's some omitted words from a passage. If you're quoting a passage and you're omitting some words, add the ellipsis, the 3 dots, to signify the part that's missing. All right, so let's talk about one of my hobby horses, writing in the active voice. So we do know that I want you to write in the active voice, not the passive voice. Okay, I want a quick vote. Tell me if this is active or passive. The tribunal was told by Jim that the victim lost consciousness. The tribunal was told by Jim that the victim lost consciousness. Active or passive? Votes are coming in. I've got one vote. The tribunal was told by Jim that the victim lost consciousness. 2 votes in. Any more? Okay, the votes are for, we've got 3 votes. Active, active, I don't know. It's passive. One of the telltale signs for passive is was told. And if you like, the object in passive communication precedes the verb, and the subject follows the verb. That's the technical side of things. But let's look at the active counterpart. Here's what I would like you to write instead of the tribunal was told by Jim that the victim lost consciousness. I would like you to say, Jim told the tribunal that the victim lost consciousness. So Jim told the tribunal that the victim lost consciousness. Okay, so that's active. Generally, it's simpler, and what you find is that it's more direct in that your focus is on the doer immediately. You're looking at the person, the animal, whatever it is that's actually going to do something, and then you describe what it does to whom. If you're writing in the passive voice, you're looking at the recipient and you're waiting for something to happen, and you then have to trace back to find out who did or said or whatever to the object, which is round the wrong way. It's you can get away with it, but it's slightly harder to follow. And if you continue to write in the active voice short sentences, you can really quickly understand something with clarity quickly. Now, because I mark so many assessment pieces, the passive voice makes it really hard. If I find that I'm slowly getting my way through an assignment, it's telling me that this is not written well. It hasn't been written well. Whereas if I'm able to move through it smoothly, yes, 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 it tells me that there's active voice short sentences. So there is perhaps arguably some self-serving reason why I'm asking you to write in the active voice. But remember, of course, that if you're writing for a judge or a client, or you're writing in a document, you want to keep it simple in that regard. So other examples? Yeah, sorry.
John, it's Greg speaking.
Yes, Greg.
I just wanted to ask, the reason that you're focusing on this is to, if, for example, you're advocating, the active voice is something that gives you better control of that advocacy, but also in the telling of the argument. Is that your point?
Absolutely. Yes. Whether it's a written or an oral communication, using the short sentences, using the active voice means you convey the message more effectively and simpler. The recipient can pick up on it quicker. Yes, I understand you. And if you get it right in front of a court, then you have the dynamic that you want, which is the nodding. Okay, I'm with you, I follow you, I follow you. As opposed to the quizzical look of, no, you're losing me here. Do you understand the difference? So it is important, I think, that we get it right.
Thank you, John.
No, thank you, Greg. Now, if you use, I use Word, I use the latest versions always, you'll find that there are a lot of good tools to assist you in terms of the manner in which you write. And if just as an exercise, if you haven't learned how to use the proofing tools in, say, Word, please do so. Just as this is a quick diversion, go to the top left-hand side, go to File, go to the drop-down, go to Options, and you'll see third one down, proofing. And from there, you can undertake a fresh search, rechecking the document. And if you've got it set up in a way that I like to see, it will give you your readability statistics at the end of the task. Those of you that have worked with me before, you've probably seen me do that in Introduction to Law or whatever, but try that later and file options proofing and try and get your readability statistics. What you want to do is get your reading level down. If you've got a number of, like 17 or 18, odds are you're writing in the passive voice. It will show up how many sentences you've written in the passive voice. It will also indicate that you're using too many words per sentence, etc. So it gives you some really good feedback, effective feedback, in terms of the manner in which you write, and you can learn from that. Okay, so in order to write in the active voice, we need to identify that we have a subject, we have a verb, and we have an object. So what you want is you're focusing on the subject. I hope I've said that consistently tonight. You're focusing on the subject. So the subject is, if you like, the doer, the agent of what is happening. So John hits the ball. That's active voice. John is the doer, is the subject. The verb is hits, and then we have the object, the ball. Okay, as opposed to the ball was hit by John, which is where you put in the object first and the subject at the end. Okay, so you don't want to put what was done to by the doer at the end. So in a simple situation like that, you might think, well, there's really not much difference, but you'd be surprised how much better your writing is if you can consistently write in the active voice and follow it through. And as opposed to a situation where people swap and change, and then it becomes even almost harder than if they're consistently in the passive voice. I hope that makes some sense. So the active voice is effective because it's simple, it's direct, and often those who write in the passive voice omit the doer altogether. That's another reason why you want to go to the active voice. It requires you to be more informative. I'll give you an example. The mirror has been broken. Active or passive? The mirror has been broken. We're getting some votes coming in. Okay, so we've got 3 votes. Active, active, active. No, I think it was passive. It's a trick question. The reason I say that is, let's have a look at it. It worked. Let's go back to subject, verb, and object. So the subject is the doer. We want that first. The verb is the process of doing something. And the object is that to which something is done. So John, subject, hits, verb, the ball, subject, verb, object. That's active. Switch it around. And if we have the ball, which is the thing to which something was done, that's the it's done to, as opposed to the doer, which is by John. So here we have a situation where the mirror has been broken. What we don't know is who the doer is. So someone broke the mirror is more in the active voice. Sometimes if you write in the passive voice and you don't have the doer altogether, then you have less information, is part of the reason what I'm suggesting. Okay, so I'm just going to give you a case law example, and I'll just read this, see what you think. This was a case called Gypsy Jokers Motorcycle Club against Commissioner of Police, 2008 HCA 4. So it's a High Court decision. Gypsy Jokers Motorcycle Club received a fortification warning notice from the WA Police, advising that the fortifications to their clubhouse must be removed because the clubhouse was a place of resort for organised crime. The Gypsy Jokers appealed. Commissioner sought to rely on a provision which allows some information to be kept in confidence in order to protect ongoing police investigations. Now, here's what the statute said. This was the difficulty. The Commissioner of Police may identify information provided to the court for purposes of review as confidential if its disclosure might prejudice the operation of the Commissioner. And this is the important part, and information so identified is for the court's use only and is not to be disclosed to any other person, whether or not a party to the proceedings or publicly disclosed in any way. There's a lot of words in that. I mean, that was just a single sentence. I stopped halfway, but it's a single sentence. Now, the High Court said that's poor drafting. This is relevant for you because you'll be drafting material. They particularly didn't like that part that I stressed, which was in the passive voice, seeking to issue a command and yet not contain a subject. And this is what the majority judges said. The subsection, which is the part that I stressed, continues in terms cast in the passive voice. A legislative drafting practice as undesirable as it is frequent. The information is not to be disclosed to any other person, including a party to the proceedings, and is not to be publicly disclosed in any way. But one asks, disclosed by whom and under what sanction? Now that's what the High Court said. So if you really want some proof as to why this is important, think about those words of the High Court. The subsection continues cast in passive voice. I love this. A legislative drafting practice as undesirable as it is frequent. So don't fall into the trap. Okay, any questions then about active, passive? What I'd recommend, do a little bit of reading. You can Google it, there's lots of material. There's a lot of good stuff in the book, in Ramsey's book, and you can use the tool, the tools in Word, which will help you to train yourself in that regard. Another thing I don't like is finishing a sentence with a preposition. I recommend against it. Technically, it's not completely wrong, but it's not desirable. So prepositions are words that introduce information to the reader. So examples of prepositions are the words in, to, from, for, or with. So the DVD is in the brief. It's a prepositional phrase because the word in is the preposition and the word brief is the object of the preposition. But if you add something to a prepositional phrase, you'll have more information. So my client's mother cried becomes my client's mother cried with tears of joy. So adding something at the end provides that extra bit of information. And when I say don't finish a sentence with a preposition, if you find that you finish a sentence with the word in or to or from or for or with, then you could probably do better, is what I'm getting at in part. Another little hobby horse of mine, and I told you I'd enjoy week 4. Week 4 is where I get to vent some things. Another little hobby horse, I'm not very keen on using language unnecessarily. Now, sometimes you might think I'm being really harsh, but we can always do better. And we're in advanced statutory interpretation and advanced drafting now. So we are at the vanguard. We are the ones that must show the way. What's wrong with this? I read through it. Very simple. Not just necessarily jargon is one of the questions. when I talk about abbreviated language. I'm talking, yes, jargon, I'm talking about verbose language, but I'm also talking about superfluous language. And I see this a lot. You know, was it Mark Twain who said, "I'm sorry about the length of the letter, but I didn't have time to write you a short letter"? More specific, yes, Siobhan. So it takes talent to write using less words. Okay, so I'm going to give you these 4 words, these 4 words in a sentence, and tell me how we can reduce the length. I read through it. Can we make it 3 and say the same thing? What if we just said, I read it? Now, you might say the word through adds something. I don't think it does. I think I read it is just as good as I read through it. I know it's only a small thing. Take care with your possessive apostrophe, and unless you're writing a heading, please use a complete sentence. Now, also in the study guide, you'll see some very good information about subordinate clauses, adjectival and adverbial clauses. And I'll just read from the study guide. Adjectival clauses and adverbial clauses are descriptive in nature. They give us more information about one or other components of a sentence. Adjectival clauses tell us about the subject or the object, and adverbial clauses tell us about the verb. So, having said, use words economically, I'll also encourage you to add a clause if it adds to the meaning in an effective manner. So, the plaintiff changed the locks. Very simple, but we can add a clause to make it better. The plaintiff, comma, having experienced this situation previously, comma, changed the locks. So I'm suggesting in a way that whilst I promote the use of short sentences in the active voice, sometimes you can take a very short sentence, add a phrase, or a clause rather, and it will assist. Another example, the defendant brandished the knife. That's fine. It's active voice. But a little better, the defendant brandished the knife in a threatening manner. So adding a clause to that. The applicant filed the document. That's fine. The applicant filed the document, comma, which complied with the court's requirements. Better. So you can see that what we've done there is just added some information to assist the reader. And what we're doing by adding the clauses of that nature, which are descriptive, is we're identifying exactly what the clause relates to. And that can be important if it imposes or creates an obligation. So what we're talking about is the adjectival clauses, which tell us about the subject or the object, and the adverbial clauses tell us about the verb. So the adverbs. Okay. All right. Thank you. Now, let's talk about some other things. Precision in your language when describing time. Have a look at Sykes and Clery. It was 1992, 176 CLR 77. You might remember this if you're old enough. Phil Clery had been elected to the House of Representatives. Another candidate, Sykes, who only won a handful of votes, challenged the validity of the candidacy, Clery was a school teacher. He'd been on leave without pay for about 2 years. He was elected while still officially a teacher and thus an officer under the Teaching Service Act. And this case dealt with separation of powers because essentially it said, look, a member of the executive cannot be a member of the legislature. And it deals with Section 44, good old Section 44 of the Constitution. Any person who holds the office of profit under the Crown or any pension payable during the pleasure of the Crown, out of which any revenues of the Commonwealth, is incapable of being chosen as sitting as a senator or member of the House of Representatives. The High Court interpreted Section 44 of the Constitution. Justice Dean dealt with the question of tense, saying that was important. And this is what was said. Subject to one exception, the verbs of the section are all in the present tense: is, holds, has, does not. But the exception is the critical verb phrase in the future tense: shall be incapable. Do you see the difference there? So the drafter of the legislation has been consistent almost all the way through in writing verbs using the present tense, and then throws one in the future tense, and it throws the whole thing. And Justice Dean said, clearly the section is directed to the imposition of minimum requirements which, regardless of the views of Parliament, a citizen must satisfy during the period in which he or she is actually a senator or a member of the House of Representatives. Now, as it turns out, the court disqualified Mr. Clery because he was still an officer on the day he lodged his nomination and on the day of the election, which was contrary to Section 44. Just because he was on leave without pay does not mean he was no longer an officer, and it doesn't matter that he's under the state parliament, not the Commonwealth Parliament. But in addition to that, you'll see that there was another problem, and that was that he was citizen of another nation. And you'd think, we got that in 1992, you'd think that the parties would have learnt from that, which led to, and of course I'm referring to the whole issue that has plagued us recently through Section 44 of the Constitution. All right, now you've been very patient. I will wrap it up. I had planned to get further, but next week we will advance this discussion. And I would really like you to read this book and use online resources about the content and do your study. As I mentioned, and study and do your reading in advance. As I mentioned at the start, if you haven't already identified your area of practice and the law reform that you wish to consider for your assessment, please do that this week and make a start. Okay, before I leave, are there any questions, comments? You've all been very patient. Thank you. All good? Okay. All right. Well, we'll see you next week. All the best. Bye then.